Welcome to the Moran Center's virtual workshop, our training on helping clients navigate unemployment benefits. My name is Megan McClung, and I am the school-based civil legal clinic attorney. This is our third of 3 trainings that are designed to help our volunteers understand the basics of some common areas that have been impacting our families during COVID. For our new volunteers, a little bit of background on the Moran Center, which has historically represented youth and young adults in criminal and educational proceedings. And it started the school-based civil legal clinic in April of 2018 to meet more of the legal needs of families of Evanston-Skokie District 65, addressing major issues of health and safety in our students' lives. The clinic supports families and children with free legal assistance and advice on civil matters such as evictions or family law, which were the subject of our last 2 trainings. Today, the focus is on unemployment benefits, one of the next most common matters presented at our clinic, especially during COVID. So much has changed because of COVID, and our families more than ever need help navigating the waters to get much needed financial assistance when they lose their job. Our clinic currently is working remote, same as our courts. And the goal today is to help our volunteers understand the basics of unemployment benefits. And the goal of the clinic is to address the family's unemployment benefit issues because it impacts a child's well-being and success in our schools. A child's health really starts with having food and financial support at home. I'm fortunate today to have 2 very distinguished panelists with me who are also volunteers with the clinic. The first has spent 25 years working with the public and nonprofit sectors to further social justice, including 15 years as an attorney with Legal Aid Chicago. She is currently a principal at Danube Center for Strategic Advocacy and is the director at the Confidentiality Institute. Welcome, Alicia Aiken. And could you please tell us how you've been involved as a volunteer at the Moran Center?
Sure, thank you, Megan. So I have a student in District 65, and honestly, after I left Legal Aid Chicago, I kept kicking around in my head, there really should be a legal clinic at like the elementary schools in Evanston. And then I found out about the Moran Center. So I attended a training, but in all honesty, it took me a while to actually flip the switch to attend a clinic. And once I finally got myself into a clinic, I think it was literally the last clinic before the pandemic shutdown happened. But that got me engaged, and then 2 different people came through who had unemployment issues, and I represented one of them at a hearing, and then I represented another one in the administrative appeal.
Thank you, Alicia. Our next distinguished panelist is a trusted advisor to U.S. and global human resources and executive management teams on a wide range of employment issues, including unemployment claims. She's currently Vice President and Associate General Counsel of Corporate Functions at R1 RCM Incorporated. Welcome, Carrie Palmer. And can you please tell us how you first learned about the Moran Center's legal clinic?
Sure. Thanks, Megan. I joined or started volunteering for the Moran Center pretty soon after its inception in 2018. A friend of mine was one of the first volunteers and told me about it, and I live literally across the street from the district, but not in the district. I am right on the border. And really was looking for an opportunity to help to my immediate local community, and so I have manned a couple of the intake days, a few of the intake days. Some days just sitting and meeting and talking with my fellow volunteers and not getting too many folks in, and other times we've been extremely busy, so that's been fun. And then also I've assisted on a couple of recent unemployment claims as well, which were really either post denials that had not had an appeal yet, or just in general information about the employment process.
Well, thank you, Carrie, for being with us today, too. I am so fortunate and grateful to have both of you as expert advisors, not only to me and also for the volunteers, but helping today with this presentation. The benefit of having both of them is that they bring two different perspectives. We have Carrie, who brings the perspective of the employer side, and we have Alicia, who brings the perspective of representing those whose benefits were denied in the appeal process. So as we move through the training, you'll get to hear those two different sides. And as we move on now to our first slide, really today is all about the focus on the role of the volunteers. I know when my first unemployment benefits question came in through the clinic, I needed to quickly brush up on it. And so I kind of know how you feel in that question of what are these? How do we navigate through them? And so this is really designed to help any attorney who hasn't done this before. We're really starting with the basics. And so the role of volunteers, even those who have never done this before, is to be able to assist a client who presents to the clinic and help answer their basic questions, and really to help them manage their expectations. Sometimes they come to the clinic and what they have is the denial letter in their hand. And so it's a matter of helping them with that, how they appeal. Sometimes they come to the clinic and they've already lost their job and they want to know how to apply, something really basic. And some of our clients, because we have an income qualifier, they're so low income, they don't have the benefit of a computer, which is necessary to apply for benefits, which is pretty much online right now, especially during COVID. So sometimes when no other options are available, we have volunteers who will assist with actually filing the unemployment benefits claim. And we'll go more into that later. And then also when necessary, just referring clients to outside pro bono services. So as we move into this, really the goal of our training is to talk about the basics. What are they? What are unemployment benefits? And it's a state-sponsored insurance program to relieve the economic insecurity caused by involuntary unemployment. Now there's been some changes because of COVID, and we'll get into that more throughout the presentation. But the bottom line here is for unemployment benefits, to be eligible, they could receive up to 1/2 of one's average, have to move this, average weekly earnings for 26 weeks in a 1-year period. And again, we'll get in a little bit more to the calculation of this as we move through our presentation. And then the other big thing is who is eligible. And employees must be able, available, and actively seeking work. And what that means is that they need to certify, and that certification is done through IDES by calling a phone number or by going online and certifying that they are still able and available to work. Now, because of COVID, there's been some changes to this. It's something that we will get into more as we go out through the presentation. So we're going to go into what is this big picture overview, the applying, denial, and appeal process. We're going to break it down even further and how to apply, how IDS calculates benefits and who is eligible. We'll go through the benefit denial and steps to appeal. We'll talk about COVID and how it affected unemployment benefits. And if time permits in the end, we'll actually review a sample denial letter that I sent to those who are participating live today and navigate a new client intake. And again, in the end, our goal here is to inspire new volunteers to take a pro bono case, because you can get great experience representing a client at the administrative hearing level where it's done by phone call. This slide is taken from Legal Aid Chicago, and it's a great, while it's a little blurry, it is still a great resource for understanding the unemployment application and appeal process. So this is the big picture overview. And if you start at the top here, you know, there has to be separation from employment. And whether an employee quits or is fired, the general advice to always give them is apply for benefits. There's no harm in applying for benefits. And so to go through that process online with IDES, which stands for Illinois Department of Employment Security. And this is the website to go to, or if it wasn't COVID, to go to the local office, but those are closed right now. And so what happens next is the employer can protest the benefits, and then the local IDS office will investigate and make a determination. And if they determine that there will be a denial, and we'll go into reasons why unemployment benefits are denied, then the client will receive that denial letter. And a lot of times that's what they present with at our clinic. From there, that denial can be appealed. And what's really key to note is that it needs to be appealed within 30 days of the date of the decision denying the benefits. And from there, usually we instruct the clients to make that appeal themselves because that's always included in their denial letter. So they should fill it out and they should send it in as soon as possible. After that, they should get a determination back or a date for a hearing with a referee who is like the administrative hearing officer. And this, so the ALJ, the administrative law judge, this is the first stage where a pro bono attorney like you could get involved, and it's the best stage to get involved. You'll hear more about Alicia's experience with that later in this presentation. There'll be a hearing where evidence can be presented. The employer is represented by an attorney, such as Carrie. And if it's denied after that hearing, like their benefits are still denied, then it can be appealed to the Board of Review. Again, there's a 30-day requirement to get that appeal in. And then it goes to the Board of Review. And from there, if it's denied again, then it can be appealed to the Circuit Court underneath the Administrative Review Act. And it goes to the Circuit Court where they basically defer to the agency on the issues of fact, but when it comes to issues of law, that's where you can really turn the tide and get a win for your client. So now let's break it down. That was the big overview. And we're going to break this down and go back to how to apply. Because a lot of times we have clients come in and really what they need is just some advice and referral to IDES. And here's the site that you can go to apply. Now, if they have their own computer, they should do so. If they don't, and there's no other resource out there, such as using a neighbor's computer or some other trusted source, typically they would have a child who maybe has a Chromebook that they use for school that they could use to apply. And what you should advise them is that they need to have this certain information. If you are going to assist them because they still need help in applying, this is information they may need to come back so that you can go through that application with them. Now, how are benefits calculated in Illinois? What's key to know here is that IDES will calculate the benefits. It's not something that you need to do, but we're going over it here so that you have a general understanding of how it is calculated so that you can also help manage the client's expectations. So to be eligible in Illinois, they must have earned at least $1,600 during their base period, and $440 of that must have been earned outside of the highest paid quarter. So what is the base period? It's really the earliest or the oldest of the last 5 calendar quarters preceding the claimant's filing. And part-time workers are eligible so long as they meet this threshold income requirement. And if their hours were reduced, generally they're not eligible, but there's a chance they may be. COVID kind of changes this up as well, and we'll get into more of this as we go along. Carrie or Alicia, is there more that you want to add to this at this time? Okay.
Yeah.
So,
the computers will figure it out. And again, it's free to apply. It is complicated to figure out the base period and the quarters and to make sense of all that language, but it is free to ask.
exactly, exactly. So, and to help manage their expectations, a lot of them, they just want to know, well, how much can I get? And here we have, I'm just going to change our view here. How are benefits calculated in Illinois? And to calculate the weekly benefit, IDS at their website, you can actually plug in some of the information and get it a determination, which isn't the actual determination, it's just an approximation that you can use. But what's good to know is that the maximum individual weekly unemployment benefits in Illinois is currently set at $484 for an individual. With somebody that has a dependent spouse, that can then go to $577. And if somebody has a child, it can be $669 as the maximum weekly unemployment benefit. Now, something to note here is that an individual can only claim their dependent spouse. That's a dependent spouse who is not working, or their child, but they can't claim both. Or if they have more than one child, they can't claim two children. It's only one child or one spouse. Is there anything else that you'd like to add to this, Alicia or Carrie?
I would just add that sometimes you'll get folks who will say, well, I saw that the maximums are this, and I did not get, $669, and I have a child. First step is, remember, there's a sliding scale based on what you were making before, as we talked about, so people misunderstand that. And it's always available on the IDS website as well. So the first place to go and look is that, and sort of cross-reference. The sliding scale is both on the dependent spouse allowance as well as the dependent child allowance. So it's all dependent on how much you made before during the relevant quarters, and that's the best place to start. So sometimes people think that the maximum, like they should get the maximum if they made more than $669 a week, for example. So if they're in their prior role, they were making, $1,000 a week, and they are not getting $669 a week now, it's likely because that's not where the calculation came out for them. So that's just something to remember when going through, especially, and I've had in the clinic, actually, people come and say, I don't think I'm getting enough. And so this calculator helps provide that checkpoint as well.
Point. And Carrie, as we move to this next slide, if you could go over this, this is about how new benefits are related to COVID, because there's a lot of acronyms out there like PUA and the CARES Act. And Carrie actually helped put together the slide to help kind of break it down. Some of you may remember the CARES Act extended benefits and actually allowed an additional $600 a week when the pandemic hit, which was something entirely new when it comes to looking at the history of unemployment benefits. So Carrie, if you could talk a little bit more about the new benefits related to COVID.
Sure. And one of the outputs of COVID is I got to add pandemic response team to my resume as an activity. So I've spent a lot of time with these and other offshoots of the response to COVID over the last what sometimes feels like 2 weeks and sometimes feels like 15 years. So it's been about 6 months. So I'll go through all three of these. The terminology is really not all that relevant. They refer to separate acts, either executive orders or passed by Congress that impact unemployment. The first is the Federal Pandemic Unemployment Assistance Fund. This act essentially expanded the pool of those eligible for unemployment benefits. Prior to COVID, in general, gig workers, freelancers, and people who are self-employed were not eligible to receive unemployment benefits under regular unemployment, and this act expanded eligibility. The Pandemic Emergency Unemployment Compensation fund essentially extends by 13 weeks the eligibility for unemployment. So right now, when you looked at the very first slide, it said generally it's 26 weeks of unemployment. Generally, during this COVID period through December, it's actually December 26th. I don't know why they have a different date. It's an additional 13 weeks. So the total would be 39 weeks of unemployment and not 26. And then our most recent addition and subtraction from funds that are available as pandemic relief. Many of you may recall that early on there was an additional $600 that was added to that was available in unemployment that expired July 25th of 2020. But Illinois applied for a fund under FEMA, which is the Lost Wage Assistance Fund. And in Illinois, it essentially provided certain qualified people with an additional $300 of unemployment. And you have to meet certain qualifications, including receiving at least $100 a week in unemployment already. You would then get an additional $300 a week in benefits for a 6-week period of time, essentially between August 1st and September 11th. So that's also expired, but you may get folks who come into the clinic who are looking for, who were qualified and may be entitled to it from a retro perspective.
And the big thing to note here is that while these are federal, the way to apply for these is through the Illinois IDES website.
That's right.
And so if anybody comes to the clinic and says, how do I get these federal benefits? They still have to apply in-state through IDES, who manages it.
And also for the LWA, there's no application for it. The IDES just determines based on what you put in your initial application, whether or not you qualify for that additional supplement due to COVID-related reasons.
Okay. So now that we talked about...
Just really quickly on that too, if you're appealing, take a look at what they put as their initial reasons, because you may want to add some, see if you can provide additional information that has to do with COVID. They may say, my plant was shut down. But if the plant was shut down because there was a quarantine or a mass, a breakout of COVID at the plant, then you might be able to qualify for this additional $300. So just keep that in mind. Sorry to interrupt, Megan.
Oh, Alicia, did you want to add anything?
Well, I just wanted to add that the other category in the PUA, the Pandemic Unemployment Assistance, that's different is that if you are a traditional worker, but you are not going to work because of a COVID-related reason. So you have been exposed and have to quarantine, you are caring for somebody, you have COVID and you can't go to work, or your kids are home from school or camp because of COVID, then you can qualify under the PUA. And this is so new that it's causing a lot of confusion. And one of the most confusing parts is that, so both the people that I represented were fired early before the pandemic shut down. They were denied traditional unemployment benefits for misconduct, but then they were required to stay home to care for school-age children who were doing school from home. And so we had to fight to get them PUA because everybody kept saying, but they were fired for misconduct, so they can't get it. And I was like, no, they're home and they can't work because of COVID, so they get PUA. And we were ultimately successful, and I don't know if unemployment is clearer on that issue now or not.
Yeah, it is kind of a moving target, and I think that will come to light as we move through these next slides. Here we are talking about the able and available to work requirement. And Alicia, you gave those nice examples. Just take a look here. So able and available, I think, Carrie, you're going to go ahead and talk about this one.
I'm happy to. I think that the able and available is essentially the point of this is that, is that the applicant must certify essentially on a weekly basis that they are available for work should it become available. For different people and during COVID, that is different. So for example, if you're home let's just point earlier, if you're home because your children are at home because their schools are shut down, by way of example, you don't have to show that you're able and available to go outside of the home to work. You just have to be able to show that you are, if work were to be available that you could do from your home, and in fact you could do it from your home, that you're able and available for work. There is some confusion about whether or not you actually have to certify under PUA. Our advice is certify. Try. If they say you didn't have to, great. You just wasted, they just wasted 3 minutes of their life, right? But if the consequence of not certifying is a loss of benefits, and trying to get it back after you've lost them is much more complicated than taking a few extra minutes to certify.
Yeah. And then Alicia, can you help us understand what did able and available mean, or if you're not able and available, what was an example of that before COVID?
So the purpose, it goes back to the core purpose of unemployment, which is like you are a worker and you are working and you lose your job and you need some money to ensure that you can eat and have shelter while you are looking for a new job because you are a worker. If you lose your job and you would have been eligible for unemployment under the standards that we're going to talk about in a minute, but you decide, you know what, I don't want to get a job, I'm going to go back to school full time. You don't get unemployment benefits because you're not able and available to work. You have switched your identity from worker to student. Or you lose your job and you would have been eligible for unemployment and you certify for 3 weeks. And in week 4, you have a horrible car accident and you are hospitalized for a month. You are not able and available during that month. So technically, you're not supposed to get benefits during that month because you were not looking for work, you weren't able to work. If you recover and it's still within the same year and you have some weeks of eligibility left, you can then apply again and certify that you're able and available to work. Right? Gary, I got that all right, right?
I'm just checking my notes.
Sometimes it's like taking the LSAT trying to
right.
All right, thanks for sharing those examples. And now let's see, let's move this over. So if we look at separation from work due to COVID-19, this is where it's not entirely clear. This is kind of a moving target, but we do know a few things. And really, somebody is eligible if they're confined to home due to a COVID-19 diagnosis. They can still apply for unemployment benefits. Or if they need to care for a spouse or parent or a child diagnosed with COVID, or they had to leave work due to a child's school closure. And right now in Evanston, all schools are closed and there's no indication that they're going to open anytime very soon. Or if you're temporarily laid off due to COVID. But there's not a separation from work due to COVID if they left voluntarily due to their general concerns about COVID, or if they're currently receiving some kind of paid leave, like if they're on furlough. Is there anything else that you want to add to this, like some example cases?
I have an example actually it displays an interesting quirk of unemployment law. When you apply, you have to tell them the week that you left work and they will assess your eligibility for that week and then future weeks. So I know of a person who was on furlough from the YMCA in Evanston and applied, but then after she applied, the YMCA said, you know what, we're going to pay you for 1 more week. So she actually got denied benefits because at the time that she applied, she was still being paid. But she wasn't denied for the rest of the year, but she had to go back in and make a new application that started a week later. after the payments stopped, but she didn't really, she was like, I don't know why I'm not getting them. Maybe it's because I got paid for one more week. And I was like, that's exactly why. Go reapply. So it's a weird quirk. They determine your eligibility for a specific week, and then it continues for another 26 or 39 weeks after that.
The only other thing I would add to that is, you know, they have this language in the FAQs. Again, this is all just, you know, new, and we have a couple of anecdotal examples, but we certainly don't have the full scope of what's happening right now. But I would just say the general concern about COVID is not a specific concern about COVID, right? So if it's just, I'm just not comfortable coming into work. If somebody works at Walgreens and they say, I'm just not comfortable going, you know, that you're probably not going to get unemployment. If they say, I am not comfortable going because I live with 3 immunocompromised individuals and I have to help care for you know, for my son, and, you know, those may be specific enough concerns concerning COVID that you could fall into one of the exceptions. So, you know, help people like really dig into the reasons why. Is it just that you weren't comfortable generally, or and I think when you're talking to clients, that's part of getting into it, is what is it specifically that was concerning you? You know, well, I was afraid, you know, I wasn't going to be able to make the schedule because of the school schedule. Okay, that's a reason. That's clearly a reason to get unemployment. You know, just and I'm also worried about COVID. Okay, maybe not that. You know.
Yeah, so I kind of jumped ahead here to the next slide. So moving now from some of the COVID impacts on unemployment benefits, now we're going to talk about who is eligible. And again, this is just talking about it, unemployment benefits generally. This is pre-COVID. This is how IDES makes the determination. And an individual can be eligible for unemployment benefits if they were terminated, separated, discharged, laid off, furloughed, if there was a reduction in force, fired, or let go. That means they could be eligible for unemployment benefits. And again, as Alicia said before, there's no harm in applying. They should always apply. But the big unless here is they won't be eligible if they were terminated for misconduct. But they should always apply and let the employer fight it and put in the reasons why there was misconduct. But they should always apply. Somebody can also be eligible if they quit and they can show good cause for having to quit. And we will get into all of this in more detail in these next slides, because this is really what the denial and the hearings involve. So on this next one, I'm going to turn it over to Carrie to talk about what is misconduct.
Sure, and I think the key here is, and we purposely put the section 602A definition in here, because what an employer may consider misconduct, a violation of their rules, or, you know, bad behavior in the workplace, and they don't want this employee there anymore, versus how it's defined under the law is very important for us as the lawyers representing individuals applying for unemployment, because it really has to fit into this definition. It's not termination after a performance improvement plan, generally. You know, while an employer may say, well, we gave them, you know, reasonable notice of the expectations of the job, and they weren't meeting the expectations of the job, and you know, that they will still qualify for unemployment. And it's, you know, an employer may fight it or may not, but in most cases, if it's based off of a PIP, an employer is going to lose. So it's helpful to keep this definition in mind. The rules have to be reasonable, you know, and what is reasonable? You know, but generally it's the reasonable person test that they would use. You know, it seems like a reasonable rule. They've been there's been warnings about it, information provided about it. As an employer, when we are protesting a claim because we're claiming somebody engaged in misconduct, we're providing our employee handbook with a specific policy. We're providing a prior warning letter if the individual received a warning letter, and specific examples of how that how that policy was violated. So know that that's the documentation that's likely being provided if an employer is protesting. And you know, so that is sort of the distinction, I think, between what is just general poor performance and misconduct.
Here's another slide that I think really covered a lot of what you were talking about, Carrie, such as, you know, the knowing a repeated violation of a reasonable policy. Can you expand a little bit more on, does it have to be written? Is it something that just had to be said to them?
So I can tell you that, you know, just an experience of cases as an employer that we've won and lost, much more likely as an employer to win a protest if it was a written policy. If it is not a written policy, it's going to have to be really clear that somebody was, you know, warned about the behavior before, and that it is something that sort of would be a common sense rule. So if you think about something like about drinking on the job, let's say an employer just doesn't have an employee handbook. So they didn't write down like, oh, you can't drink on the job, but then they sent an email out that says there's no drinking on the job, or it's pretty obvious you can't be drinking on the job, and somebody showed up drunk, probably still going to win, right? That's probably going to be misconduct, even if they didn't have an employee handbook. But you know, you can't be, you know, you can't stand within 10 feet of this particular machinery because it's a safety violation, and that's not written anywhere, and there's no signage to that, and we fire somebody for that, then that would be, that'd be an example of something that likely would not be considered misconduct under the law, and the claimant would likely be successful. Those are two examples that I'm aware of, and I should also mention that I'm not giving examples of current cases under my or former actual cases of my employers, and I'm not a representative of them for these purposes. I should have put that disclaimer in there.
Good disclaimer there, Karen.
I can talk about some of the things that we see happening for low-wage workers, just real quickly as examples. You're hired in Spanish, you talk to your boss in Spanish, the rule is posted solely in English, and then they say you violated the rule. That's not a reasonable rule because you literally didn't know about it. A different, you know, some places try to prohibit people from speaking Spanish in the store between employees. Legal aid lawyers would argue that's a violation, that's not a reasonable rule. And I can talk about this one because it's an appellate case, but one of my clients overslept for work, and he had a problem with oversleeping, and he set 2 alarm clocks, and after 3 months of no problem, he set 1 alarm clock and the power went out, and he overslept. That is not misconduct because it wasn't intentional, it wasn't deliberate. Oversleeping is the definition of an unconscious act and not deliberate, but we had to go all the way to the appellate court to get that ruling.
Wow. Great job with that one. So Carrie, what are these misconduct questionnaires and how do these help?
Sure. So, and this is for all the volunteers. You know, when you have time later, when you when you actually have a case. There's 2 different questionnaires that are sent when there's a case of misconduct. One to the claimant, one to the employer to fill out. And we don't need to go there. We don't have time to go there now. But the reason they're useful is you will see as you're doing an intake what the employer was asked, what the claimant was asked, and be able to really, and that will help show you what the IDS is going to be concentrating on when they're making the determination about whether or not there's misconduct, and as a result, can help you form your arguments that it was not.
And so another way that somebody can be eligible and they're separated is if they quit for good cause. And Alicia is going to go more into quitting for good cause that is the employer's fault, and then when quitting for good cause when it is not the employer's fault.
Yeah, so it's harder if somebody quits, or it's called a voluntary leave. It is a harder case for sure. But the law does say that if somebody quits for good cause attributable to the employer. So, but one of the most important parts of that is you have to make some reasonable efforts as the employee to address the issue, to resolve it, to try to hold on to the job. And so when you represent somebody in one of these, it becomes all about where the problems that the employee describes, can you prove they really existed? And then did the employee make reasonable efforts to resolve the problem? So the classic example of that is the employer moves the factory from North Chicago to South Holland. And so theoretically you could drive there, but it's a drastically different location. And so that's the employer's fault. They moved it and you quit because you can't get to the new location. They change your job to something that you're not qualified to do. So this is an example from the case precedents where somebody was hired to be an administrator, and then the organization assigned her to teach classes for students who had been diagnosed with behavioral disorders. And she went to her boss and said, I have no training, I have no support, this is really hard, I don't know how to do this. And they said, you'll be fine. And so she quit, and that was considered good cause. It's attributable to the employer. What's really hard about this when people quit because of sexual harassment, unlawful discrimination, or abusive behavior by coworkers, if you have any experience doing traditional employment discrimination litigation, those are extraordinarily hard cases to litigate and prove. And the unemployment fact-finding process is not in of itself designed for that level of inquiry. I think Carrie's shaking her head because she agrees with me. You are technically, if you can prove it, then that is quitting for good cause, but it's extraordinarily difficult to do. The other thing that comes up is we see people who quit, who it is called a quit by the employer, but it's really not a quit. So one example is somebody says to their boss, my parents are sick, I gotta go home. And the boss says, take whatever time you need, and they go. But that it's the supervisor who said it, and the client takes them at their word at whatever time you need. And then the boss says to the supervisor, where's John Doe? And he says, oh, you know what? He's been gone for like a month. And they're like, you know what? He abandoned the job. That's a quit. And then John Doe comes in and says, you told me, take whatever time you need. And then it's a question of, did John Doe reasonably, honestly believe that he had permission to be off work for that length of time? The thing that is, that it rarely comes up, but it is important to know about is if you quit because of domestic violence. So that doesn't have to be attributable to the employer, but it has to be some kind of verified domestic violence. You have to offer some kind of evidence, protective order, court order, statement from police, hospital, doctor, lawyer, advocate, counselor, something like that. And you have to have notified your employer before you quit that staying on the job is fundamentally unsafe for you because of domestic violence. If you meet that standard, then you can actually quit the job, and it's not technically the employer's fault, but you should be eligible for unemployment. But so few people know about this provision, it's very unclear to me. It was put in about maybe 15 years ago, and it's unclear to me how much it actually gets used.
One other circumstance that I've seen that that you should be aware of is sometimes employees, when they're at the end of a performance improvement plan, for whatever reason, they think it's better to quit than to be terminated. They don't want it in their file. I mean, I can tell you as an employer, we're not producing, under Illinois law, we're not allowed to produce that employment file to anybody other than you, or, you know, pursuant to a court order. So just as a way of reference, it doesn't, I don't know why people have formed that belief, but some do. So in some cases, they'll say, well, you know, I don't want to be fired. Will you just accept my resignation? And then the employer accepts their resignation, but they were on the verge of being terminated for what would clearly have been a qualifying reason for unemployment, that being performance. So it's good to ask those questions as well, because in those circumstances, when they resign in lieu of being terminated for a qualifying reason, they may be able to get unemployment.
Yeah. And thank you, Megan, for putting up that additional slide, because there are some additional reasons that you may be able to quit that aren't attributable to the employee, to the employer. and they're up there on the screen. I'll be honest with you, I'm less familiar with these. And I don't know, Carrie, if you've got more experience with these as reasons.
Well, the
But
COVID related reasons are the ones that are the newest ones, which are not the, situation attributable to the employer, but still allow for benefits.
I mean, I think the message is if somebody comes in and says, I quit, the answer is never, well, you're out of luck. I think the answer is there may be a way. It's free to apply. And I think it's worth it to take a look at the law, and we'll make sure through the Moran Center you have access to the digest of adjudication precedents and the sort of guides that help analyze this question. But it's always worth it to see, is there an angle here? Is there an angle here?
Right. And also know that as an employer, that their employers don't have unlimited resources in many situations. And the situations where they're really going to protest are where people actually resigned and where people were pretty bad actors. Some will go even further than that, but know that if resources are limited, those are the two big areas where protests are coming in. So be prepared if they did resign. Really going to have to get evidence to counter that, because those are the cases those are more frequent. So they drive up employers' rates, which is why employers protest, by the way. And B, they're harder to prove. So these are the ones where you really got to get the documentation in order. You do for all of them, but they're the most difficult.
So this is where I think we're benefiting from your two perspectives, from the employer side and from the defense side. And I thank you for sharing them. If anybody has questions, please, by all means, put them in the chat box so that we'll be sure to address them during this presentation. And the best part is that both Alicia and Carrie, if we have a unemployment benefits denial come in and there is a question, is it good cause that's attributable to the employer or not? They both offered to help assist and advise on that. So thank you. Another question about eligibility, and this is just something to note, is whether if somebody comes to the clinic and they are a non-US citizen, the question is, can they be eligible for unemployment benefits? And the question is, and the answer is, it depends. And so you'd want to ask them questions about, do they have valid work authorization? Have they been earning wages? And are they here under lawful permanent residency? It used to be known as green card. Or are they residing here under PRUCOL, which stands for permanently residing under color of law? Some examples of that is that they have a DACA or a VAWA or other kind of visa that allows them to work here and if they are laid off, they could be eligible for unemployment benefits. So, and if in the end, we have a non-US citizen under one of these categories, they've applied and they've been denied, that's a time where we will refer them to the appropriate immigration legal aid agency for assistance. So here we are at applied and denied. This is really where our volunteer attorneys can sink their teeth in and get administrative hearing experience and having what we look at as a mini trial. And so what happens here when they've applied and they've been denied? Well, the first thing is to have the client fill out that appeal letter to make sure that they send it back in and go through the steps that are listed on the denial letter. I am going to have Alicia jump in here and talk more about how to appeal that initial denial and just some common things to make sure you do and things that you want to avoid doing as well.
Are you talking about like actually filing the appeal to the initial denial?
After advising the client to file the appeal, what happens next?
So technically it goes through a reconsideration inside of IDES. I've never seen a case change on reconsideration, and then it gets assigned to an administrative law judge, which is called a hearings referee, and it gets and you get a hearing date, and it is possible you don't get a huge amount of notice on those hearing dates. Like it might be a week to 10 days ish, and you can ask for it to be continued, but they don't love it. So just know that's a little bit tricky, but you can get it continued. And then you have a phone hearing, and the phone hearing is you're on one line as the lawyer, and it was like this before COVID, that you're on one phone, and then now with COVID, your client would be on another phone. When I was doing them in the old days, my client would come into the office and sit with me, and we'd be on speakerphone. And then the employer is on the phone, and then the employer can have a representative. It might be a lawyer, it might be a non-attorney employer representative, and you offer evidence. Here's the thing about these hearings: they are they're unpredictable. They are phenomenally interesting to do. I mean, I think they are the absolute best way to get trial experience, to just see what you can do on your feet. When I was at legal aid, I was a generalist, and so I basically had 3 specialties, and one was domestic violence, one was subsidized evictions, and one was unemployment hearings. So you make a gigantic difference, because if you are prepared, you probably know unemployment law, or you're applying unemployment law potentially more correctly than the referee, because the referees tend to do hearing after hearing after hearing after hearing with no lawyer in the room, nobody's bringing up the law, and they just want to get through the day. I mean, it's a really hard job for them. And so by being in that room, you can say, hey, we're gonna run this in an orderly fashion. I have a witness. My witness is going to be on task. I'm going to make a brief opening statement that directs your attention to the relevant law. I'm going to make a brief closing statement that ties the facts to the law. When the other side is saying irrelevant or sort of really going off track, I'm going to object. And that's going to help the referee keep control of the hearing. But it's a little bit, whatever variation you think you've experienced with trial judges in a courtroom, the variation in what you might experience with an administrative law judge, in my experience, is wider. Carrie, I don't know if you have any thoughts about the appeals.
No, I think that's right. And also, a lot of times you're the only lawyer in the room. Employers don't always or even often send a lawyer to an unemployment hearing. So it's that's kind of fun too. To be able to sort of, I mean, you sometimes will get it, but to Licia's point, you're educating everybody in the room sometimes.
Yeah, and one of the biggest things I think in these hearings is that there is a lot of confusion for employers and sometimes for hearing referees about the difference between I was legally allowed to fire this person.
That's right.
And this person is eligible for unemployment benefits. Employers don't understand, well, employers who are representing themselves and are not sophisticated, which there's a lot of, they don't have any understanding of that distinction. They think that if they don't win this hearing, they're gonna have to rehire the person or pay damages.
That's right.
So sometimes one of the most important things you can do in that room is remind everybody, I am not arguing that this person should get their job back. I am saying under the standards for unemployment, they are eligible for benefits payments.
Right.
Just to refocus the room on the real standard.
All right, so moving on a little bit, since we're down to about 5 minutes, one thing I want to go over is if you volunteer and you're at the clinic, we have a handout there, questions that you can ask if somebody presents and they have an unemployment benefits issue. And so these are the questions to go through, such as where was your last date of employment? What was your last date of your last day? How long did you work there? What were the reasons for the termination? Was it due to COVID? Have you already applied for benefits? And do you have any IDS documentation of a finding? There's also more questions listed on the handout. And we also have some other handouts just to assist volunteers with this issue. And so the big thing is for somebody who presents to the clinic, the advice is, again, apply. There's no harm in applying. It's free. And if you apply and you get a determination, be sure to certify, certify, certify. And the other thing is that they should apply using a computer. Smartphones do not work with IDS website. And if they don't have access, we could possibly assist them with filing. Carrie made this point here. If they come to the clinic and say, gosh, I think there's an error with what they awarded me, or they forgot to add in my child, and I should be getting more in benefits, then tell them to call the IDES to try and change that error. And what they should do is call right at 8:30 a.m. That's when they're most likely to maybe get somebody, or at least get closer in line in the phone queue. And so the last thing is, again, if they appear with a denial letter, tell them to appeal, and then to call the Moran Center if they have further questions, or if their appeal of their denial is denied. And as you heard from Alicia, that's most likely going to happen. So what we want to do is, once you do that intake, you tell them to apply, to make sure that we then complete the intake. Look out for when they get that hearing date, so that you can then jump in and represent them at that hearing. So I think we have just a few minutes where, for those who are participating live today, we sent you in advance of this presentation a sample denial letter, and you can see it's quite long and lengthy. It does give a lot of explanation about how to appeal. But what I've done is extracted from here the sort of the issue, why this our fictitious client Peter Parker presented and what happened. And so I'm going to turn this over to Alicia just to kind of break down, you know, what if you're a client, if you are a volunteer at a clinic, what to do if a client presented by the name of Peter Parker with this denial.
Sure. So yeah, so those of you who received a copy of the notice, this is drawn directly from what a notice that they're issuing right now looks like. It is a 5-page notice filled almost entirely with boilerplate language that is a repetition of the statute and the rules. And it's hard to read. It's hard to process. Even as someone who reads legal notices for a living, these are particularly difficult. So the two most important pieces of information you're going to extract from that document is on the document itself, not on the slide, is up in the right-hand corner. It says date mailed. That's the date that matters to IDES. Very frustratingly, in the old days, the envelopes used to have a postmark on them. And so often we would get something that said, for instance, date mailed September 20th, and it had actually been mailed the 23rd. And so we could come back and say, our deadlines really run from the 23rd. I noticed recently this year that the envelopes have no, because of the way the post office is doing it now, there's no postmark date. I am telling you right now, especially right now in COVID with post office issues, the date it was mailed may actually be like a week earlier than when you received it, but I don't think we're going to be able to do anything about that. But you need to know what that date is, because the client's 30 days to appeal run from the date mailed, not the date received. And then the second thing that's important is the determination. And so what's up here on the screen is, this is the actual analysis of the facts. So first off, it tells you that Peter Parker was denied because of misconduct, which is different from being denied for voluntary leaving. So you now know that you're analyzing it under 602A, that definition of misconduct under the Illinois statute. And then the denial is effective August 29th, 2020. So that's the week that Peter Parker applied. And this is really what it looks like with the 12/31/9999. That's not a typo by me. That's what a real notice that came in earlier this year said. And then below that is the actual, what they call the claims adjudicator, which is the person who investigates for IDES. This is this person's conclusion about what happened based on a phone interview that they did with the employee and the employer, if they were able to reach both of them. And so you would look at it and you would say to Peter Parker, tell me what happened. And Peter Parker might say, you know, I quit because they were harassing me. I mean, it has happened that the facts that Peter Parker describes to you bear no relationship to what's on that notice. So if that happens, and you need to deal both with what Peter Parker says happened, but also with what someone thinks happened based on what's on this description. And I got to wrap this up because we're out of time. Insubordination will come up a lot. It is kind of a, in my experience, Carrie, no disrespect, but employers understand it's an effective buzzword. But there are actually legal standards about what kinds of behaviors do or do not count as insubordination. And so you want to sort of find out from Peter Parker what happened on the day that you got fired. What did you say? What did they say? What was written down? What did you understand? And then take those facts and go back to the law to see how those facts line up with the law.
Very good. I wish we had more time to really dissect this a little bit more. No pun intended with this being the Spider Lab. But last but not least, you know, there's always more information for volunteers that can be found on Illinois Legal Aid Online. Can't say enough good things about this huge resource for pro bono attorneys. We also have some other facts sheets to help our volunteers. And then we have Alicia and Carrie that we can reach out to for advice and help on the cases as well. So thank you so much for attending this last of our 3-part series, our virtual training for volunteering at the Moran Center School-Based Civil Legal Clinic. And this one on unemployment benefits. You know, I was looking at the history of it, and it was started 85 years ago, unemployment compensation through President Roosevelt signing the Social Security Act. And, you know, who could have seen how much that it was needed today? And it's something that you can really help our families who are struggling to make ends meet. You know, helping them with these unemployment benefit issues and claims and denials really makes a difference for the students in our community and how they thrive and survive at school. Before we wrap this up, are there any questions? All right. There's Charles. Any questions at all?
There have not been any questions that have been submitted as of yet.
Well, if anybody has a question after we leave this, you can always email me. And again, thank you so much to Alicia Aiken and Carrie Palmer for lending their time and talent and their expertise.
Thank you.
Bye.
All right. Have a good evening.
Bye.
Bye. Thanks, Charles.
Thank you.
Bye.